Hi everybody, this is Arkady Frekhtman. I'm a New York City personal injury trial attorney. And one of the things attorneys do, trial attorneys, is they watch footage. They watch footage of other attorneys. And there was a recent trial that actually resulted in an amazing verdict. The verdict was over $500 million. And it wasn't in New York, it was out west, I believe in Nevada, near Las Vegas, if I'm not mistaken. But I wanted to do an interesting video where we watch the opening statement and I can comment on it and discuss it as we watch. So let's get into it. Let's check this out.
A closing argument is not evidence, just as what is said in opening statements is not evidence. The arguments are designed to present to you the contentions of the parties as to what the evidence has shown and what inferences may be drawn from the evidence. Your purpose as jurors is to find and determine the facts.
So this part right here is actually where the judge instructs the jury. This is before the opening statement. The judge is telling the jury a little bit about how everything works, that the opening statement is not evidence, but it's rather what the evidence will show according to the plaintiff, the person suing, and the defendant. So each side's idea of what the evidence will be.
Under our system of civil procedure, you are the sole judge of the facts. You determine the facts from the testimony you hear and the other evidence, including exhibits introduced in court. It is up to you to determine the inference.
Okay, this is the opening right here.
Thank you, Your Honor. Jumping the gun there a little bit. So, welcome back. It's now time we get to actually talk about evidence in a formal way and what the evidence is going to show in this case. It's a simple case. Impaired drivers are responsible for the harm that they cause, right? Basic safety rules. So the story of this case, it's October 26th, 2019. It's about 10 p.m. Defendant Raspberry is headed out for a night on the town. Defendant Raspberry gets his night started by smoking a few blunts. Defendant Raspberry fills his Altoid container with ecstasy, and he hits the road. Defendant Raspberry first goes to Aliante Casino, where he gambles and drinks for about an hour. It's around 11 o'clock p.m., Saturday the 26th. Defendant Raspberry leaves Aliante, gets in his car, and drives to the One Oak nightclub, where he continues drinking. Has a few more margaritas. 1:30 a.m. on the 27th, a Sunday, Defendant Raspberry gets in his car and drives to the Spearmint Rhino Gentlemen's Club, where he continues drinking. A couple more margaritas. He's there until 5 a.m. on Sunday the 27th when he leaves. Not to go home, but to drive to the Oasis Bar and Grill, where he takes a number of shots of Jaeger. At about 7:45, he leaves the Oasis Bar and Grill, and he starts driving. Defendant Raspberry turns west on Tropicana. The speed limit is 45. Defendant Raspberry hits the gas. 60, 70, 80. He sees ahead on Rainbow in blurry vision because of all the substances he's taken that the light looks like it's probably red, and he presses harder on the gas. 90, 100, 107. At the same time, a man and a woman in a white SUV enter the intersection on a green light. The man and the woman, husband and wife, are on their way to church. Defendant Raspberry is right near the intersection now, and you can see clearly that he has a red light. He hits the gas, enters the intersection. The impact sends the Nissan SUV flying through the air, literally. The Nissan SUV bounces off a bus before smashing between two stopped vehicles that are waiting at a red light.
Yeah, so I mean, this is a horrible, horrible crash. And you see the technique that this attorney uses, I believe, It's known as alignment. So what he's essentially doing is he's not advocating, right? He's not saying, oh, because when you try to advocate and you try to argue, then the jurors might immediately think, well, why is he arguing right away? Right? And they might not believe you because you're being too much of an advocate. So what he's doing is just giving you the facts. Defendant Raspberry took this ecstasy. We have proof of that. Defendant Raspberry, drank this alcohol, whatever it was. And he's just giving you the facts. The car went down the street. It's a very powerful technique, because essentially what that allows the jurors to then do is to make their own conclusions. And when the jurors make their own conclusions, that's their own mind saying, hey, that must be what the argument is. And you just give them enough information for them to make those conclusions, but you don't advocate. You don't have to shove it down their throat or tell them. It's a very powerful technique. And a lot of the best attorneys use something similar to that. And it's also taught by some jury consultants that have written books about this. So.
This is a video from inside the bus, and the impact after the SUV goes flying through the air strikes the bus, and you can see the impact that it has on this unfortunate bus driver. This view is from the front of the bus, and the collision happens on the very far left side of the screen. It gets captured. And this view is the side view from the bus. And you'll see after the SUV bounces off the bus itself, it somehow gets wedged between. If you can see, there's two vehicles in the two lanes next to the bus. You just see the tops of those vehicles. You're going to see that the SUV somehow lands between those two vehicles and gets wedged in there. Marshall and Nympha were the man and woman in the Nissan SUV, and I'm their lawyer. This is Marshall and Nympha a number of years ago. They've been married at the time of this crash. They've been married for 37 years. Marshall, he started, they lived in the Philippines. They grew up in the Philippines. And when he became an adult, he went into the priesthood. Wanted to become a priest. And he went through seminary for a few years and decided that it wasn't necessarily exactly what he wanted to do with his life, but he wanted to serve people. And so he transitioned and became a doctor. And then he became a surgeon. And he took care of people in the Philippines as a surgeon for a number of years. And he met Nympha, and they fell in love, got married, and started their little family. Marshall thought that it would be a better life for his family to come to the United States. And so he put together the immigration process and came to the United States, and he had to come over initially on his own because he had a kind of an important skill set. So he came over and got things established for several months, and then was able to get his family over. And Marshall, anyone who knew him, he spoke very good English, very conversational, very gregarious, happy, fun type of guy. But his English was not good enough for really complicated test taking like they require for surgeons and doctors. And so in the United States, he tried to become a surgeon but was not able to pass the tests that were in English. But he was able to pass the tests with his background to be a registered nurse. And so he spent 20 years or so as a registered nurse in the United States, where he raised his family the rest of the way. And anyway, and he loved it. He loved it.
So you see what he's doing here? He's giving you background information, but he's also painting a picture and telling a little bit of a story, right? He was from the Philippines. He wanted to be a priest. Then he pivoted and he became a doctor because he wanted to serve people, a surgeon, but he came to America because he wanted a better life. And he fell in love, he got married. So anyway, this entire story, this doesn't sound like somebody who's like one of these fraudsters, right? That's trying to pull one over on you, that's trying to do something like, win a payday, you kind of become endeared to this person. You find out a little bit about them, about their life story, about their family, about their values. And then, so it's very important to give this kind of background information.
Loved what he did. He was known, this is a picture of the family before they came when they were little, with Marshall and his kids. Here's another one. This is them here, Marshall and Nympha. And this is a picture of the family about a month before the crash. Marshall was very, it was very important to him to help the people that were in the Philippines, and so he would go back there sometimes and help, but he also, in the medical world, sometimes in the United States, there will be large packages of medical equipment that have like an expiration date, but it's not dangerous, different tubes and different things like that, and they just don't have the supplies. And so he would make a point of when things would be getting thrown out, that he would make sure that it got to places that could use them and help people, and it was a passion of his. And Marshall had just retired the year that this happened, and they were financially good, and he was dedicating his life to his religious beliefs. They were Catholic, and they felt strongly about helping people, but also with his family and doing things in the community, specifically getting help for people in healthcare here and there. This is them dancing also just shortly before the crash. And this is Marshall with his first grandbaby, who is now 18. So this is 18 years ago. Marshall suffered catastrophic injuries, and he died at the scene. And Nympha survived, saved by good doctors at UMC Trauma. As you can imagine, her life is not going to be the same, not just because she suffered some injuries, but emotionally and the way that she's been impacted by really her best friend not having. And the family. It's Marshall was the guy that everybody went to. And you're going to hear testimony about how a couple of years after Marshall died, his oldest grandson got cancer, and just how the impact to the family, he was the guy they'd go to, right? For doctor advice and things like that, and just for all the sorts of things that they would go to, he wasn't there. And it just created a huge void for them.
Right, so that's another important point, because a lot of times people will text me or people ask me questions, well, how much am I going to get? I have a C3, C4 herniation. You see, it's not just about the medical diagnosis on a piece of paper. If that were the case, that everybody who has a C3, C4 would get exactly the same amount. But it's also the impact of someone's life. Like this person died, so obviously, but he's saying that this person was not just, another husband, he was also like the go-to person who would give parental guidance and all types of guidance to the entire family and, friends and family. So they would come to him for guidance, right? And so now he was missing. So now they had no one to go to. He was kind of like, the family person with the most wisdom and so things like that. So that's very, very critical to do a deep dive, to be able to really take a snapshot and picture of a person's life and how that injury or the death has affected the family, how it ripples and how it affects. The more you could show, the more people it affects and how it affects them, the stronger your case is.
After the crash, blood draws are taken. Defendant Raspberry tests positive for alcohol, THC, meth, and ecstasy. Defendant Raspberry's blood alcohol level taken hours after the crash is still 0.205. And they've been able to identify that means at the time of the crash, it would have been 3 times the legal limit, about 2.40. This is Defendant Raspberry. And we're not going to play any clips of his deposition at this time, but we will introduce some of his deposition because a decision's been made that he's not going to come and testify. And so we'll play some clips from his deposition so that you can see some of the things that he said. But Defendant Raspberry agrees that the crash in this case involved intoxication with alcohol, marijuana, and ecstasy. that his vehicle was going more than double the speed limit, and that his vehicle ran a red light. But, and he'll also say that he had 4 counts of DUI resulting in death or serious bodily harm, 4 counts of reckless driving, these are his convictions, a DUI for alcohol, and 2 counts of possession of illegal drugs. So how did we get to this point? Defendant Raspberry claims that he's not at fault for the crash. He says that he doesn't know who.
Sorry, I hate to interrupt, but I think we may need to approach.
So basically, this is another technique that the lawyer is doing. What he's saying is, okay, if this is so clear, right, if this guy's convicted and he admits that he was drunk and he was on drugs and he crashed into this car that's just stopped, why are we even here? How did we get to this point? Well, it's because now he's saying that he's not at fault. And then there's an objection. And the important thing with objections is, a lot of lawyers are scared of objections. They think, oh my God, I don't want to get an objection. It really doesn't matter. In fact, sometimes you want an objection because the fact that the other side is objecting means they don't like something, right? And what are they trying to hide? Are they trying to hide the truth? So as long as you stay confident during the objections and just thank the judge, say, thank you, judge. And a lot of the times the other side may object, but that objection gets overruled. And even if it gets sustained, you can just pivot and move on. And it really doesn't matter.
And the defendant Raspberry claims that it wasn't his fault. He refused to acknowledge that he was the one driving the car. So the job of the jury is to investigate, to consider the motives of the parties. Why did they do what they did? The reasons driving their behavior. The means. Whose behavior resulted in what happened here? Who had the power to do things differently to prevent this from happening? The injuries. How did the defendant's actions impact the plaintiffs, right? What harm was done? And the alibis. What are the defendant's excuses? What are their defenses? The job of the jury is to identify the truth, to find the truth. And so this case began after defendant Raspberry was already convicted, and this was our complaint that we initially filed. We filed a lawsuit against defendant Raspberry for what he had done, and in our complaint, we made allegations that he had been negligent, that he had been reckless, that he killed Marshall, and that he injured Nympha. And you see those are paragraphs 41 and 42. There's many paragraphs in a complaint. But I show those because defendant Raspberry answered the complaint, and in his answer, identifying those same 2 paragraphs, he said that he is without sufficient knowledge or information necessary to form a belief about whether or not he was negligent or hurt somebody. And then he put up some affirmative defenses, and he said that the damages in this case that plaintiff suffered, if any, he says, were caused by their own negligence. And he says in his 4th affirmative defense, the damages, if any, in this case, were caused by third parties that defendant Raspberry had no control over. And then he takes a step further in a prayer for relief and says he requests of the court that the plaintiffs get nothing in this case, that their complaint be dismissed in its entirety, and that he be paid attorney's fees for the trouble of having to defend the lawsuit.
So this is another interesting technique, and I've seen other lawyers do this as well. What he's essentially doing is he's taking the answer or the appearance of the defense counsel. So the insurance company hires a defense lawyer, that's known as insurance defense counsel. And when you file a lawsuit, they invariably, almost always will say, oh, we don't have a sufficient belief, or we deny, and they'll file their standard affirmative defenses. It's almost like boilerplate. But the defendant, the actual policyholder, in this case, the driver, this guy Raspberry, he has to verify that as true, which I guess he did. So now what he's saying is, how ridiculous is this, right? You could hear what he's saying. And I think that's a really good argument, because a lot of times the lawyers just do that without really thinking how it could be used at trial. But it's a pleading, meaning you can use it at trial, and it could really be effective, and it could stir anger in jurors, like you killed somebody and you're saying they should get nothing and they're at fault, you know. So let's see what else he does.
There were not good grounds for those positions, to take those positions, and we filed what is called a motion for partial summary judgment on a number of issues in the case where the evidence is totally clear. And we asked the judge to make a decision on some of these critical areas so that there's no question. And so you don't have to decide many of these things. So just reading, Defendant Kevin Raspberry, who was severely intoxicated and under the influence of drugs and alcohol and traveling at approximately 107 miles an hour, ran the red light, entering the intersection and violently colliding with plaintiff's vehicle. Defendant Marshall Escobia passed away due to the injuries sustained in the crash, and Nympha sustained serious injury for which she received treatment. That is undisputed. Those are facts of the case established, so you don't have to make any decision. That's what it is. And it is undisputed that Defendant Kevin Raspberry's actions caused the death of Marshall Escobia and caused serious bodily injuries to Nympha Escobia. And it is hereby ordered that plaintiff's motion for partial summary judgment is granted. So the reason why we're here with many issues decided is because they've been brought to the judge, and since 100% of the evidence went one way, the decision was made by the judge. So what is your job if the judge has already found Defendant Raspberry caused the crash? You are the appraisers. You decide the full and fair value of all that was wrongfully taken. And you know these well. And I'm so excited to see you all as members of the actual jury that we have now. The physical, but you get to evaluate these and go through them and identify what is the full and fair value of these things: the physical pain, the emotional suffering and anguish, the disability, the loss of companionship and comfort, the loss of consortium, the relationship between spouses, between partners, the grief, the sorrow, the loss of enjoyment of life. And as you are listening, we're going to have some witnesses who are going to talk about the harm in this case and what has been suffered, and evaluate what they're able to say and what you can sense below the surface and how this has impacted them. And ultimately, you arrive at the amount that you think the full and fair value that a reasonable person would take all of this on, how much is required to fairly compensate that, to make these, both sides of this, balance. You also decide punitive damages. Was Defendant Raspberry's behavior reprehensible? Should Defendant Raspberry be punished? We also expect the defense to provide alibis. Alibi 1, that Defendant Raspberry should get a pass on punitive damages because he has taken responsibility for his conduct. But that's not going to be the evidence. He admits that the driver of his vehicle was going 107, that the driver ran a red light, and that what the driver did was reprehensible and that the driver should be punished. But then he takes no responsibility and claims that he doesn't know who was driving the car. He admits that he had to be cut out of the driver's seat at the scene and admits that there was no one else in the car, but does not accept that he was the driver and does not accept that his conduct caused the crash. The basis for his dispute is going to be, quote, "I'm not a reckless person." Alibi 2, Defendant Raspberry should get a pass on punitive damages because punishing someone for one bad decision is not fair. Defendant Raspberry will admit that he was a habitual drinker who would get intoxicated and go driving. At a minimum, at just one bar, 3 nights a week, he would go take multiple shots of Jaeger and go off driving afterwards. He was a habitual smoker of large quantities of marijuana and then would go driving after. This is what he would do all the time. This was his standard operating procedure. This is just the first time that he killed somebody. And when he admitted those things, it wasn't to clear a conscience. It was in the setting of him knowing that we had all of the evidence, including bartenders that told us information and things like that, before he admitted these things. The best estimate from him that he will indicate of the intoxicants that he took in that timeline that I went over with you of that night is 3 blunts, 5 margaritas, 3 shots of Jaeger, and ecstasy. He doesn't admit to using that, but that also showed up in his blood tox. And when he was asked why on this particular night, this particular day he went and did this, he said, well, it was the first time I was off on a weekend in a while, so. We expect the defense.
So this is another important part of any opening statement. You see, what he's doing is he wants to get punitives, and this verdict, I believe, was like $550 million. So obviously, a big chunk of that was punitive damages. And he mentioned the standard in Nevada is that it has to be like reprehensible conduct, which this was, going 107 miles an hour, crashing into a stopped car, being, high on drugs, alcohol, the whole 9 yards. But what the lawyer is doing here is he's evaluating what the defenses may be, right? Because as soon as he sits down, the defense lawyer is going to get up and the defense lawyer is going to make arguments. So rather than just give his presentation, he also thinks, what will the defense arguments be? And he preempts them and he says, before coming here today, we had to look into whether, and then he asks a question and then he answers it. So he's basically responding to the defendant's argument before the defendant makes it. So then when the defendant does make it after the plaintiff lawyer sits down, it's much weaker because the plaintiff lawyer already brought this up and already kind of addressed it. So now you're going to bring the same thing up again, and it kind of weakens the defense point. So it's a very good, and here he's talking about the alibis, right? What they're gonna say to get out of punitives, and he's basically saying why it's all a bunch of baloney.
To say that he should get a pass because he's already being punished criminally. He's learned from his mistakes. This alibi suggests that if you do something that is so reprehensible or that is criminal, where you have to go to jail for your behavior, that somehow takes away the need for you to come in a setting like this on the civil side and make sure that things are done the right way. They are 2 different systems. There is no crossover of the punishment, civil and criminal. Defendant Raspberry will probably be in prison for a long time for criminal behavior, but that doesn't mean he gets a free pass for the harm that he has caused the actual victims of what he did. Defendant Raspberry should get a pass because he's remorseful about the harm he caused to his victims and their family. But again, this will show to not be true at all. This is a still shot of Defendant Raspberry looking at a picture of Marshall and Nympha. Remember I showed you some pictures of Marshall and Nympha. He was shown a picture of Marshall and Nympha, and he was asked who they were. And this is the look on his face when he answered. And he says, these are the people that are suing me. And the disdain, I don't know, what is that look?
I'm going to object, Your Honor. He's tested with disdain without playing the video.
This is not argument.
Thank you.
Thank you, Your Honor.
You see, again, like he does the argument, he says this is a look of disdain. The guy objects, how could you say it's disdain? You didn't even play the video, it's just a still shot. And then the judge says, yes, this is not argument. And he just says, thank you, Your Honor. So what did the objection do? Did the objection hurt the plaintiff's case? No, the plaintiff made a strong argument, the jury heard it, and the jury also heard the defense lawyer not wanting this evidence in, right, trying to hide something. So I think that just bolsters and makes the plaintiff's case even stronger. But, what do you think? I don't think it really hurts the plaintiff at all, this objection.
So consider what you see in his face as he's looking at the picture of Marshall and Nympha. And he says, these are the people suing me. And then he's asked, are they anybody else? Or are they anybody beyond just people suing you? I don't know. Were they involved in a crash? Yes. And this is after he's heard their story in the criminal case about what he has done to their lives. And he says, well, they're Filipino. Anything else you know about them? No. This is a case where we believe that the full and fair value of what was wrongfully taken is somewhere between $55 and $85 million. And that any amount less than 55 would not be reasonable. And we also are going to ask you to check the box that says punitive damages should be awarded based on the evidence in the case. Thank you.
So that's the opening statement. You see, he says, he gives a range for the damages, which is, that's pretty common. Sometimes when you know what the number is, you can say it's 85 million. And then of course you have to tell the jury, a lot of lawyers will tell the jury, but of course you could give more or you could give less depending on your interpretation, your view of the evidence. And the judge will tell them that as well. But he gives a range, which, also it could be powerful from 55 to 85. It's a pretty good range, right, for a plaintiff. And then, of course, on punitives, he's not talking about the amount, but he's just saying check the box that punitive should be awarded. And I believe the way it works here is that there'll be a separate phase where they actually do allow for damages based on punitives. So I'll look at other, I just wanted to do the opening because I thought it had a lot of nice points that could be teaching points, and I wanted to share that with everyone. But of course, there's also a closing argument. There was examination of witnesses, including a direct and a cross-examination of the wife. I believe her name was Nympha. She survived. There was also, I believe, the brother was one of the witnesses. They had doctors testifying about the injuries. So it was a full trial, and then they had closing arguments for both sides. And so I could maybe review some of the other parts of this case and then do other videos to discuss it, because I think it's, it's a really interesting case. Of course, it's a very strong liability, horrific damages, but to get, $550 million is still not easy in any case, and they did a good job. Okay, everyone, thank you for watching. Please like and subscribe to our channel. Let us know how we could help you. If you need a consultation, just text me. It's 347-566-9595. Please like and subscribe to our channel. And our goal is helping serious injury victims and families. Thank you so much. Okay, have a great day.